Good afternoon, everyone. My name is Laura Brancato, and I'm a senior attorney with the law firm of Littman Krooks. And today our Lunch and Learn will focus on mental health and the law, and specifically on Article 81 applications and Article 9 applications. If you have questions along the way, you can use the chat function at the bottom of the screen, and I'll do my best to get to any questions at the end of the presentation. If they are super case specific, we, for privacy reasons, may want to discuss them offline, but we'll do our best to answer any general questions that you have. So this afternoon, we're going to be focusing, as I mentioned, on the mental hygiene law, specifically Article 81 and Article 9, and talking more about how these statutes provide mechanisms for assistance to individuals who may need support in the community or even in a medical facility. And I'd like to mention at the outset that the types of matters that Article 9 and Article 81 are meant to address are, for the most part, pretty complicated legal and medical matters. And so it might be wise, and likely you'll conclude this at the end of the presentation, that it's important to consult with an attorney who's very well versed in this area of the law to determine the best way to specifically address the circumstances that you may be finding yourself in. And this is an ever important topic, especially in the climate we find ourselves in. Mental health and wellness is certainly at the forefront during these incredibly stressful and uncertain times. And we're finding that more and more clients are needing support in various types of ways during this period of time. We also are seeing an aging population with huge spikes in increases in cognitive impairments like Alzheimer's disease or dementia. And Article 81 is specifically meant to address some of those impairments. We're also seeing growing trends in other mental health crises like substance abuse or other just general mental health and wellness areas. So we should start the discussion with mention of the vital role of proper estate planning. So with proper advance directives in place, like a power of attorney or healthcare proxy, it is possible that family members or individuals may never need to access Article 81 or Article 9. Our firm can assist in the planning, proper estate planning to address many of the issues that can come up in cognitive impairment or mental wellness, including the preparation of psychiatric advance directives, which specifically address our clients who struggle with mental health and would allow them to empower an agent to act on their behalf in the event of a mental health crisis. We're not going to get into the specifics of power of attorney or healthcare proxy today. However, our website at littmankrooks.com has a wealth of information relating to estate planning, and you can find links there to our YouTube channel where we have a number of recent presentations we've given relating to the use of estate planning. So we'll move past that. It's a good starting point to say that there are ways to try to prepare. Article 9, Article 81 are talking about what happens when either the person who is in need has not made preparations or when preparations may not be sufficient to address the crisis that an individual might be facing. So let's start with Article 81. Both of the articles we're addressing are promulgated in what we call the New York State Mental Hygiene Law. And the Mental Hygiene Law addresses lots of different types of circumstances. And Article 81 is the statute attorneys utilize for the appointment of a guardian for an incapacitated person. You might hear the term guardian used by lay people in a variety of settings. Guardian under Article 81 is a person who is appointed by the court to manage either the property, meaning the financial and maybe real estate of an incapacitated person, or the personal needs, namely medical needs or medication management or health insurance, things of that nature. Article 81 is most commonly used for adults who have an onset of cognitive impairment. And the cognitive impairment is impeding on their functional capacity, and that person becomes incapable of understanding, the lack of their own capacity and whether or not they could be in danger, or how their incapacity otherwise impacts their overall wellness. The ultimate goal when a petitioner files for Article 81 guardianship is the appointment of the guardian. And the guardian can range in, the appointment of that guardian can last for a definite period, like 1 year, or can be an indefinite appointment, meaning that the court finds that the incapacitated person is not likely to become able to manage for themselves at any point in the future. And so when the guardian is appointed, the court intends for that appointment to last for the lifetime of the incapacitated person. So as I mentioned earlier, this is most commonly used in a scenario where a person maybe develops, let's say, an Alzheimer's disease. And we're seeing this more and more frequently, where a client has not prepared advance directives, hasn't given authority to a loved one or a neighbor or an accountant to handle their financial matters, pay their bills, or handle their personal needs matters, make medical decisions, or accompany them to medical appointments, things like that. When that happens, the only intervention that is appropriate is the initiation of an Article 81 proceeding, where the court can determine that a guardian is necessary to protect the needs of an incapacitated party. Now, the guardian can step in and manage, as I mentioned, a whole range of tasks. It's really important to understand what Article 81 cannot address. Article 81, for the most part, and there are exceptions based on the specific circumstances, but will not authorize forced medical treatment, forced substance abuse treatment, or forced treatment over the objection of the person who is alleged to be incapacitated. Article 81 is not meant to address an overarching mental health crisis if what the loved one is seeking is to admit that person to a medical facility or to seek forcible medication. That's not what Article 81 is meant to cover. And we'll talk about how Article 9 fills in the gap on that side. It's important to understand when considering an Article 81 application that the burden of establishing the party is incapacitated is very high. So this proceeding is a civil proceeding. It's initiated in state Supreme Court in the county where, most commonly in the county where the alleged incapacitated person resides. So if your brother or sister resides in Westchester County, it would be initiated in the Supreme Court of Westchester County. And it would be initiated with the filing of a petition. The petition would have to include clear and convincing evidence. That's the legal standard. That legal standard is right below the criminal standard of beyond a reasonable doubt. Clear and convincing evidence is the highest civil standard that a party would have to meet in order to be successful. And the reason I mention that is it's really critical to understand that an Article 81 proceeding is very complex. It can be very lengthy, and it will require the petitioner to prove that the person they seek guardianship over has a functional limitation and that the person is in danger if a guardian is not appointed for him or for her. So this is not something to be undertaken lightly. The petitioner, if the petition is not successful, may have to pay for the court proceeding out of their own funds. And the court will do a very thorough examination of all of the facts to be considered, and that would include a hearing. So a hearing is somewhat akin to a trial without the use of a jury. The judge would be the person deciding in most cases, but an Article 81 hearing is a longer process that the petitioner must undertake after careful consideration of what their goal is. What are you trying to achieve when you initiate this type of proceeding? We'll talk a little bit later. I'm going to use a specific example that I think will be very helpful in understanding what an Article 81 proceeding can achieve. But for right now, I'm going to turn to Article 9 And then we'll look at the differences between Article 81 and Article 9. So Article 9 is also promulgated under New York State Mental Hygiene Law. And that statute specifically focuses on both voluntary and involuntary admission to a medical facility of those who struggle with mental illness. And the statute also discusses, and we'll get into this in a minute, other types of treatment, assisted outpatient treatment, etc. But for the most part, most parties are using the portions of Article 9 which delineate how you would go about making an application, again, to the Supreme Court to request that the court grant permission to involuntary or voluntarily retain a person in a medical facility for mental health treatment. So again, much like 81, in order to initiate an Article 9 proceeding, a petition must be filed in the Supreme Court of the county, either where the person currently resides, or it can even be initiated in the county where the person is currently hospitalized or receiving medical treatment. So even if you are a resident of Nassau County, if you had a mental health crisis and you were hospitalized in Westchester County, the facility where you are being treated can actually make the application in Westchester County to have you retained at the facility. So the petition in Article 9 can be brought by a family member or a loved one. It can also be initiated by the medical personnel at the facility where a person is being treated. It can also be initiated by the county where the person, the county attorney's office where the person resides, if there are safety concerns. Again, it's a case-specific inquiry into who would initiate the petition. But Article 9 makes some very clear delineations between a voluntary proceeding and an involuntary proceeding. So it's a rather complex statute, and the reason is because, again, Article 9 affects some fundamental rights of an individual to either seek treatment or not, or be medicated or refuse the right to be medicated. So as you can imagine, that implicates some very serious constitutional freedoms that we all have to be free from unwanted medical intervention. So let's take a look a little bit more deeply. Voluntary admission in Article 9 talks about a patient who themselves recognize that they need assistance, making a written request of a facility to seek voluntary admission for treatment. And that could be substance abuse treatment, it could be mental health treatment, it can be an eating disorder treatment, all different kinds of facilities dealing with all different kinds. It could be gambling addiction, it could be any type of mental health treatment. That person, it's important to understand, though they may make a voluntary writing to come into the facility, if they later then determine they no longer want to seek treatment, it can go one of two ways. If the facility determines they're well enough to make that choice for themselves, they can also voluntarily check themselves out. If the facility at that point determines that they are a danger to themselves or to others, the facility can seek an order from the Supreme Court to retain the person for up to 60 days for further mental health treatment. So even though it might be voluntary on the way in, there is a chance, depending on the circumstances, that the person would be held based on an application to the Supreme Court. The flip side of that is involuntary treatment. And that, to be honest, is the area that most clients come to our firm with questions about. How can I help a loved one who's in crisis if they are refusing treatment? So the standard for involuntary treatment is also substantially high. It's the same clear and convincing evidence standard we talked about under Article 81, but under Article 9, you must have certain medical documentation in order to support your petition. Medical documentation is not required under Article 81. Under Article 9, if you would like to seek involuntary admission, you must include the certifications of 2 treating physicians who will, in an affidavit, so it's a sworn statement, will swear that the patient is either a danger to themselves or to others, and that's an imminent risk. It's often called the 2PC admission, and that refers to two primary care physician type of admission where you would need this medical documentation. So therein is where we find our most practical challenge. A lot of times we might meet with a family of a patient who refuses to be evaluated by anybody. So how would you meet the 2PC standard, right? That is a challenge, and we make certain recommendations depending on the client's specific situation. And that's something we can certainly meet with individual clients about. But that is one of the challenges in the Article 9 arena, which is if a person is ill enough not to want to be evaluated, we do see some challenges there regarding how to meet the burden of providing two physicians' affidavits. And by the way, the physicians have to have examined the patient within 10 days of the petition. So it can't be a physician's letter from 2 years ago that says Peter Smith is an imminent risk to himself or to others. There has to be a closeness in time. It can't be one doctor examined a year ago and the other doctor examined yesterday. You would need someone who saw the person yesterday and maybe someone who saw the person 5 days before that. It can't be so distant in time. As I mentioned, Article 9, and again, as we discussed in the voluntary treatment, if the court determines that the burden has been met by clear and convincing evidence that the patient is an imminent risk to themselves or to others, they can authorize the facility to hold a person up to 60 days for treatment. Now, at that time, however the period of time is set, if the facility wants to continue to hold the patient, they would have to come back to the court and continue to make the application. And that's because we all know that with proper medical intervention, most of the time you'll see a great deal of improvement within a 60-day time period. So the court will not give indefinite authority to a facility to hold a person who might be in mental health crisis. It's not like Article 81, where a guardian will be appointed for an indefinite period of time or for the lifetime of the patient. That is not the standard under Article 9. So oftentimes you will see over the life of the person, over the life of the petition, that there may be subsequent applications by the facility or by the family to have the individual retained at the medical facility. Now, it's also really important to understand, just because the court determines a person shall be held does not mean that the court also determines a person shall be medicated. Article 9 also makes very specific prescriptions for what happens when a facility wants to treat over the objection of the patient. That's a totally different application. Oftentimes they're heard together, maybe in the same proceeding, but they are not the same thing. So a person can be, it's very possible a person can be involuntarily retained, and during the course of treatment, that individual determines that they do not wish to take medication, and the facility cannot forcibly medicate based on the retention alone. They must go back to the court and seek additional authority for medication over objection. And that's usually a decision made by the treating psychiatrist, psychologist, social worker, maybe a team of individuals. It can be made in consultation with the patient. It can be made in consultation with the patient and their family or loved ones. It's different in every circumstance, but some people have the misinformation that merely being retained means that any necessary treatment will be provided, and that's not accurate. It's also important to note that when an Article 9 petition is brought, the court in the Supreme Court in the county where the action is initiated will appoint counsel, an attorney, for the individual who is the subject of the proceeding. In most counties, the attorneys are employees of an organization called Mental Health and Hygiene, the Department of Mental Health and Hygiene. MHLS is the common term for that, Mental Hygiene Legal Services. Mental Hygiene Legal Services' role in that proceeding would be to represent the interests of the individual who is the subject of the proceeding. So that if your loved one, let's say your brother, is not interested in being involuntarily held or not interested in being medicated, MHLS would be obligated to advance that position, cross-examine witnesses, review evidence, and may take a very contrary position to the petitioner, whether that be the sibling of the patient, the parent, the spouse. Very often, mental hygiene legal services taking a different position than the family, even if the person whom they represent may not be well, they are obligated to advance the interest of that patient. So these proceedings can be confrontational, it can be litigated, a longer litigated process. So it's, again, important to understand that before making the determination to undergo this type of legal remedy. Article 9 also talks specifically about one other area of the law, which some of you may be familiar with. The common abbreviation for it is the AOT remedy, the AOT treatment. That's called assistant outpatient treatment, also known as Kendra's Law. You might have heard of it, called Kendra's Law. So Article 9 prescribes how a person would qualify for outpatient treatment. I think we could all agree that most people would rather be treated in the community than in a medical facility. So there is a prescribed method for seeking something called assistant outpatient treatment. And that really, again, there's a petition involved. There are legal standards to meet. Oftentimes we will, again, be working with someone who's not necessarily interested in receiving even outpatient treatment. So the petition may involve making sufficient allegations to explain to the court why this person should be forced into assistant outpatient treatment. We find that more people are interested in the outpatient treatment because it has a longer lifespan. So for example, in an involuntary commitment, you might have a scenario where once the person has been treated at 60 days, they're doing well, they get released. It is not always necessarily true that that treatment will follow them out of the facility. It can be set up and oftentimes is set up, but the person's willingness to participate in the program is really the determining factor as to whether it will be successful. There is no ongoing oversight often in those cases, unless the facility determines the individual will need assisted outpatient treatment in the long term. So generally the AOT treatment is a longer process and gives more oversight over a longer period of time. But it is still a very significant burden. It involves medical documentation that family members may not already have access to. So again, the considerations under Article 9 are pretty substantial and would need to be undertaken only if absolutely necessary. So I think it's helpful to hear an example to understand how Article 81, Article 9 are different. So let's take this example. Alice is a 74-year-old woman living in Brooklyn. She has been living alone since the death of her spouse about 8 years before. Alice has only one brother who lives in upstate New York. His name is Mark. He's looked out for his sister her whole life as she has struggled to maintain gainful employment and has provided financial assistance for her when necessary to meet the cost of her living expenses. Her brother Mark comes into our office and indicates that he recently began receiving phone calls from Alice's neighbors, reporting highly disturbing and often threatening behavior. Alice roams the halls of the apartment building and disturbs other tenants, screams out in the night, and at times the police have been called to the apartment building. Mark also learns that Alice has not been paying her rent and that she refuses to open the door when he sends people to check on Alice or to deliver food. Mark arrives to Brooklyn to find Alice's apartment in a totally unhealthy manner. It is extremely cluttered and dangerous, and he notices stacks of unpaid bills, including utility bills and rent bills. He also notices that Alice appears not to have access to fresh food. Alice appears to be talking to people that are not present in the room and does not at all seem aware of the dangerous situation that she's living in. She also is completely unwilling to accept any help from Mark. So, what are our recommendations for Mark? It depends on Mark's goals for Alice and Alice's current level of willingness and functioning. Let's assume that Alice is totally unwilling to agree to any proceeding, and she has never signed advance directives. She has never given anyone power of attorney or healthcare proxy. If Mark sought intervention under Article 9, he might, with 2 doctor's certifications, like we discussed, be able to have Alice retained at a local medical facility in Kings County in Brooklyn for the purpose of an appropriate medical evaluation to determine if Alice is in fact suffering from the onset of mental illness or severe cognitive impairment. Mark might even be able to seek medical treatment for Alice over her objection, including medication, if the medical team thought that was an appropriate intervention. No matter how successful Mark was under Article 9, however, he would not be legally entitled to help Alice with all of the other issues I mentioned in the example. He would not be able to address Alice's bills or her quality of life. He would not have legal authority under Article 9 to carry out any other function other than getting her treatment. And again, maybe only in the short term, like we discussed. So, if Alice refused to accept help, we would likely recommend that Mark implement a plan to protect Alice and improve her quality of life through the use of an Article 81 proceeding. Under Article 81, Mark could seek to become her legal guardian and be the guardian of both her property, her finances, right, or her personal needs, including making sure she has appropriate health insurance and access to doctors and prescription medication if she chose to. So he could also seek permission from the court under Article 81 to get access to her finances, marshal her income into an account that he would take care of. He could pay her bills. He could communicate with her landlord. He could even hire someone to come and clean out the apartment. More importantly, he could probably hire a home attendant or some type of everyday support for Alice through the use of the guardianship court. And he would be appointed, if he met the burden, he would be appointed for the course of Alice's life. So he would stay in that role, fulfilling all of the needs she has, which we'll know will change over time, and making sure she was always appropriately cared for and that her finances are protected and that she is leading a healthy and stable quality of life. What Mark could not do under 81 is force Alice into mental health treatment. Remember, a guardian will not have the authority to seek mental health treatment on behalf, forced mental health treatment on behalf of an individual under 81. So while he could address many of her quality of life concerns, and he could protect her money, and he could make sure her bills get paid and she doesn't get evicted from her apartment, he cannot force her to seek a medical evaluation. He cannot force her to take medication or seek substance abuse treatment. So in that example, you see the interplay between Article 81 and Article 9. They each have defined objectives, and depending on the scenario that the person finds themselves in, one might be more important in the short term than the other. We've had many clients where Article 81 is the more important avenue to pursue to try to stabilize a person's life, protect them from being thrown out of their lifelong apartment, protect them from somebody improperly accessing their finances. That is not something we could do under Article 9. Sometimes we have clients where the overarching mental health crisis is the most important thing to address. And so Article 9 would be the more appropriate place to start. If that person received treatment and was stabilized, Article 81 would likely not be necessary. So your individual needs will really determine the best course of action for the person you're seeking to help, even if that person is yourself. So again, we're here at Littman Krooks to help you. It's important to know that many of these issues under Article 81 and Article 9 necessarily intersect with a lot of the other work we do here at the firm, making sure every client has proper estate planning, making sure individuals with special needs have the appropriate trusts in place and that their benefits are protected, making sure that clients take advantage of the Medicaid program in New York if they qualify. And we even are very fortunate at Littman Krooks to have a qualified, very renowned special education department, which can also help clients who have children aged 21 and younger who may be experiencing mental health crisis in school, and the way that impacts their access to education and their ability to function in a general education environment. We have some very specialized attorneys here who handle that kind of scenario as well, because we see some very disproportionate impacts on children who may be in mental health crisis, and we want to represent clients to assure their rights are protected as well. So we really can meet all of your needs here in this environment, and we encourage you to schedule a consultation to talk with one of the attorneys here. As I mentioned, these are incredibly complex issues. They impact everybody's fundamental right to make medical choices for themselves, but certainly as family members and loved ones, we want to protect those that are important to us. So let me check the chat function. I don't see any questions. I'll give everyone a minute if anyone wants to send a question. Usually the lunch and learns go about 30 minutes, so we're right at that point, but I'm happy to stay on and answer any questions. Okay. So I received one question before the presentation started about, can you seek both interventions at the same time? So I just want to spend 1 minute talking about that. Technically, yes, you can seek both interventions at the same time. In many counties, like in Westchester County, the judges who hear guardianship applications under 81 are the same judges who hear mental hygiene applications under Article 9. So the courts are very familiar with both issues. However, we don't generally recommend both because, as I mentioned before, one generally impacts the other. So many judges will be inclined to say, let's grant guardianship under 81. Let's see what happens if you stabilize the environment, if there are regular payment of bills, if food is regularly provided, if home care services are available, will the person's condition stabilize before I force treatment upon them? And in the reverse, Article 9 proceedings often say this mental health crisis may be acute for the moment, but certainly those who suffer from with mental illness don't necessarily have need a guardian in place forever. It could be just a temporary moment in time. So they will want to wait and see if treatment will stabilize the individual before they will grant an Article 81 guardian, which would be for a more permanent period of time. So for that reason, we generally would not initiate both types of proceedings at the same time. Also, I just want to note for everybody in the chat function, our marketing department has included the link to our past conferences on our YouTube platform. There you will find many, many informational videos and lunch and learns and other types of webinars where we talk about a variety of different issues that impact special needs individuals, Medicaid, and et cetera. And I see one question here: what specific documents other than health certifications would the court want in Article 81? That's a good question. So actually, in Article 81, no physician certifications are required. Article 81 focuses on what we call functional limitations. So for example, a person who is recently diagnosed with Alzheimer's may have many years where to go before they would need the implementation of a guardian. So they may be very high functioning for a very long period of time. So just having an Alzheimer's diagnosis and coming in with a physician certification of that would not in and of itself warrant the appointment of a guardian. But if a person who had never been diagnosed with Alzheimer's began to lose the ability to function for themselves, that person would be the appropriate subject of an Article 81. If they failed to perceive someone was, accessing their bank account and they failed to perceive that that was not a good idea, if they wandered in the street and forgot where they lived often and were in danger because of that, if they were unable to understand the lack of certain medical decision making and how it will impact their future, those are the kinds of things. So we actually don't use physician certifications in the implementation of 81. Medical records could come into play later on in the proceeding, but they're not required for the filing of the initial petition. There's a question here, is it possible to discontinue or reverse under both articles? Yes. So Article 9 is a little bit different because it's such a short duration. But Article 81, if the person who was previously declared incapacitated regains all functioning, for example, in cases of, let's say, traumatic brain injury, we have a horrific car accident, somebody appears to be permanently brain damaged, but then suddenly makes a recovery, yes, they can make an application to have the Article 81 guardianship rescinded or revised. Also, it's important to know Article 81 can be tailored. You don't necessarily have to become guardian over everything. You can just become guardian over the finances if the person still is capable of making medical decisions, or just over medical decisions if the person is capable of making decisions about finances. So you can specifically tailor, and you should specifically tailor the Article 81 to the specific need of the client that you're, or the patient that you're dealing with. There's a question, if a person travels out of New York, like Florida, what do you do? So it depends. If they're moving out of state and you have already been awarded guardianship in New York, you can seek, there is a whole provision under Article 81 to seek to transfer your authority to the jurisdiction where they move. If they're only going to be there for a temporary time, that proceeding can take a while to become effective. So it may not be imperative until you know where they will eventually stay and long term, and then transfer guardianship there. If they're just taking a trip, you would certainly keep your guardianship in New York, especially if their assets are situated in the state. How long does the Article 81 petition take? That's a really good question. The answer to that somewhat depends on what county you are filing in. Some counties have a much higher caseload. For example, as you can imagine, in New York County, which is Manhattan, Queens, or Brooklyn, we find the petitions there take somewhat of a longer time than something filed in Westchester and Nassau, Suffolk, or Rockland, for example, which could be on a shorter timeline. Again, each circumstance is different, and it's hard to say before we know the specific circumstance of your case and where you would want to file, what the delay might be. Certainly with COVID, with the courthouses maintaining very restricted access, right now guardianship applications are being heard virtually. So we do the hearing much like I am talking to you right now. I would conduct a hearing over my video. So the proceedings are moving forward. Most Article 9 proceedings are being heard in person. But to the extent that someone's in a medical facility, they may not be in person. The person in the facility may be appearing via video. And the last question is, what's my name? So my name is Laura Brancato. Again, it's been my pleasure to speak with you this afternoon about the mental hygiene law. You can always reach us here at littmankrooks.com, and we're happy always to answer any questions about this or any other area of the estate planning or elder law world. And we thank you for joining us. Bye.